Sir, we can't hear anything. Good afternoon, sir.
Good afternoon, everyone. So we stop at what did we stop last time? Hello, can you hear me?
Hello, sir.
Am
We
I
can
here?
hear you. Good afternoon.
Where do we stop? Where do we stop?
Somewhere around promissory ex-topel, the exemptions that exist.
Can you see the slide?
Yes, we can.
Okay, this is from Monsieur Stephen. Okay, we didn't discuss intention. I think we'll discuss intention as well. Intention to create legal relationship.
I don't think so, sir.
I can't hear what people are saying. No, can you hear me?
We can hear you, sir. I don't think we got to the place you just mentioned now.
But this is the last element of.
We stopped around the exemptions that exist.
Hmm?
We stopped around promissory ex-topel, the exemptions that exist. And I think the last thing you spoke about was contractual capacity.
Okay, I discussed capacity as well.
That's the thing. That's where you stop. So that's where you're about to continue from or start with. You did not go into it.
And capacity, I don't know, we would have discussed intention before. Please, can someone corroborate this thing? Because there's no way I would have discussed capacity without, discussing intention. Having, okay, just to refresh yourselves, we're discussing element of contract, and we made you to understand that for there to be a contract, there must be offer, acceptance, consideration, intention to create a relationship, and valid capacity. So intention, as I said before, when parties go into a contract, it's intention that manifests into a contract. So, but you cannot know what parties have in mind. So, in law, they apply the formula of presumption. So, to presume that someone intend to do or to go into a valid contract. So, but for purpose of that presumption, agreement are divided into three. You have social and domestic agreement, you have commercial agreement, and you have intermediate agreement. Can you hear me? Can the class hear me? Yes, sir.
We can hear you, sir.
So for social and domestic agreement, there's a presumption that parties do not intend to go into a legal relationship. And I gave you an example of that time. I gave you an example of a husband and wife promising all those promises, children and their parents. All those promises made in that context. Or social gathering, like inviting one, agreement to attend a wedding or to represent someone at a social event. The law presumes that there's no intention to create a binding legal relationship. But for where husband and wife are dealing in a commercial, or maybe they are separated, they are no more together, and the promise is made that all are binding. Then for commercial agreement, it's just the opposite of it. That is, in commercial agreement, the law presumes that the intention is to create a binding legal relationship. So, like, this is masters in business administration. In anything that has to do with commercial business, anything that has to do with making profits, sharing the dividends, and all of those ones. Anything commercial, the law presumes that when you are going into a commercial relationship, a commercial transaction, the law presumes that there's intention to enter into that relationship. Even there are exceptions in cases of pool, all this bet Niger or game. There's a clause. Usually, you have a clause known as honors clause in such agreement. So, in Bet Niger, for instance, if we win billions or millions and they say they cannot pay you, cannot sue them because of that clause that is usually contained in a pool agreement. So you see that even in commercial agreements where the law presumes intention, there are exceptions whereby even though the parties are into a commercial transaction, still not that presumption will not stand. It is like that. So and then I go to capacity, um, where we say that look, the general rule is that every person have capacity to go into a valid contract. Of course, there are there are some exceptions. There are instances whereby the law will kind of protect some persons, and so you have illiterate persons, you have infants, you have companies. For illiterate, you have Section One of Illiterate Protection Law, for example, Lagos State, which kind of stipulates the requirement that must be met for before a contract is binding on an illiterate. Of course, you could see that one of which is that the person who writes on behalf of an illiterate must write his name and address on the document. So it is the class governor that writes on behalf of that illiterate. Of course, who is an illiterate? Illiterate is someone that cannot read and write in the language of the contract. So if the contract is in Igbo language or the contract is in Yoruba language, and the person is a professor of English, you know, that person will be an illiterate for the purpose of that contract because the person cannot read and write in Yoruba language, even though it's a professor of English language. So the language of law is English language. So if a contract is written in English language and that person cannot read and write in English language, then the person is an illiterate. So um, the protection, the law is that the document is not binding on that illiterate unless you comply with this requirement. You could see under section one there. The name of the person that wrote the document, the address, you know. Also that before the illiterate signed the document, it was read over and explained to the language of that illiterate and of course understood it, you know. And the fact that the illiterate was one that instructed the person to write on behalf of the illiterate and the writing, the agreement represent fully what's the instruction that was given by the illiterate. So that's Lagos State. You also have Osun State, which also provide that how things that need to be complied with must be executed in the presence of the magistrate or presence of the customary court to appeal or just appeal as the case may be. So just taking note of that. For infants for the purpose of contract, initially that's a common law. The age of maturity, that the age at which you can go into a contract is 21 years. Now, but under the Child Right Act, it's not 18 years. So what I mean is that if I go into a contract with someone and the person is not 18 years, the law protects that person. So so for the purpose of contracts that are binding on illiterate, you could see that there are different types of contracts. Contracts for necessaries, contracts for non-necessaries, beneficial contract of service, avoidable contract, and contract that are absolutely void. So when you say that a contract is of necessary. Necessaries are things that are of importance in the life of an infant, things that an infant needs to live a life. So it's relative. An infant from a poor home would need may not be what an infant from an average home would need. So all those things vary. So, but then any contract that has to do with things which are of beneficial service to an infant, you know, they are binding. And if for instance now maybe the infant now is going to school, doesn't have a footwear to go to school, and is given a footwear that suits that purpose, they cannot say that because I'm infant, cannot, it's not binding. No, even notebook, things like that. If the infant need it, but if the parents already bought those new book for the infant, he cannot supply him for luxury. So it must be something that is needed for the infant. Such are binding on the infant, right? So, but where those things are not necessary, they are not binding on the infant. Then you have contracts beneficial contract of service like issues of extra lessons and maybe skills, apprenticeship, all those contracts because they help the child or benefit the child of that. So they are binding on the child if the agreement was entered into at that level. Because valuable contracts, such contracts, that the infant may when he reach 18 years and above, when the child is 18 years and above, may decide to accept or reject, or I mean to ratify the contract or not, and then of course there are contracts that are absolutely void. So giving some of this example here, you know, a contract for loan, you know, you grant a child a loan to pay when the child, is of age. Such loan agreement cannot be binding. So this is important because imagine you are an infant and maybe your parents let an infant and the parents left property for you, and someone now advance you loan, use that property as collateral. That when you reach age, you can pay back the loan and take back the collateral. Such loan cannot be binding on the infant at all because those of you who are working in the bank, that's why the age. Once someone is born, you must take the age your age before they borrow you that money because you want to satisfy that you are of age. IOU standard account that are not binding on the infant. Uh, yeah, as I said that before, contract of necessaries binding on the infant, beneficial services, apprenticeship, or employment, they're all binding on the infant. You know, I explained those ones before. Yeah. So then for companies also, they have a capacity. For every company, there's what they call the object clause. For every company, there's a purpose. So somebody that working in the company, you can always ask for the memorandum of that company. You see where this object clause is. That object clause will state the those things that the company is incorporated to do. So those things that the company is incorporated to do is what forms the capacity of the company. So if the company is established by way of legislation, by way of laws of National Assembly, you see the object stated in that law itself, like University of Lagos Act 1962, that establishes University of Lagos. If you go into University of Lagos Act, it will tell you what the University of Lagos can do. And that's why, because University of Lagos is not, it's not meant for construction. Even if they want to build a building in the university, they have to go and hire a builder, because they don't have the powers to do that. Even though you have builders that are even employed by the university, they cannot do construction. They cannot those things that University of Lagos to do are stipulated in the University of Lagos Act, and several other companies are established by law. So it's what is stated in that act or what is stated in the memorandum for registered companies that is the object, that is the capacity of a company. So anything that outside of that capacity is called ultra virus, that is beyond the powers of the company. So when a company does anything outside those ones stated beyond becomes ultra virus. If the company wants to do that, the first thing the company need to do is to go and amend. You can amend the law or amend the memorandum and add that to it, and then you can always go on and do that. You have cases like Continental Chemist versus Ife Candle, where this guy was working with the chemist. The chemist sponsored him to go to US abroad, become a medical doctor. When he came back and was to work with the chemist, he declined. He said that no, because the chemist don't have powers to employ a medical doctor and for services that they wanted him to do. You know, so those are the things. Those are the things. Um, So of course, you see that if you allow that to happen like that, so many things people will take advantage of ultra-virus rule and do things that are to the detriment of the company. So the new law, that's CAMA 2020, Company and Alignment that's Act 2020, try to you know provide some remedy for that. So one, you can see that in the last paragraph of the slide that the companies that are not authorized to do any activity, only business outside the memorandum. Anything that exceed the powers of the company is prohibited. You know, so if the company want to do that, a minority shareholder or a debenture holder may apply to court to stop the company from taking any action that is, beyond its powers. And also, the court also have the power of the president law to award compensation for any loss or damage that the party may suffer by reason of setting aside the transaction. So any person can be compensated if they set aside the what the company embarked upon and you incurred some damages and you're able to prove it. The court can should be able to pay you compensation for that. Right? Any question? Any question, please?
No, sir.
Okay. Okay. So with that, we that's all you should know regarding the element of contracts. So we're moving to terms of contracts. Yes, remember that for every contract it must have the terms. And when we're defining offer, to say that offer is expression of intention. It can be oral, it can be by conduct, it can also be by writing. And in the age of information and technology now, all those e-transactions by the Evidence Act of 2011, all e-transactions are deemed to be documents, are deemed to be transaction in writing, all electronic. So if you are going into an agreement and you are sharing your correspondence online through emails, through WhatsApp chats, through messages, or you did online agreement with someone without physical listening, all those agreement online are deemed to be agreement in writing. So, those terms of contract, whether orally or in writing, are what we're looking at here. And there are some agreement that will have one page, some will be quarter page, some will be 100 pages, some will be 200 pages. And in those agreements you may also have other terms incorporated by reference. If you look at your admission letter, for instance, you basically give you an offer for admission, but then they would have made reference to University of Lagos Act and rules and regulations of the University of Lagos by reference. So what I mean is that even though you have one page admission letter, all the laws and regulations of the university are also part of that by reference. So the expectation was that you would have looked for these laws and read them, look for university regulations and read them before before accepting the admission that was given to you. And that's what I expected. That's what I expected you would have done. And I also hope that's what you did. Was it what you did when they gave you admission letter? What do you do? Do you care to read the University of Lagos Act and the regulation before accepting? Or you just accept and went and start giving thanksgiving in the church? Which one do you do? Who can share with us?
Thanksgiving, sir.
Yes. Adele Hannah of Cancer, Leonard colleague. You said I didn't hear you. You said you didn't read it. You didn't do what?
To be honest, I'm just sharing about this for the first time. I wasn't aware that that Unilag has any act that I needed to read before accepting the offer
Ah,
for admission.
oh my goodness. So, and then the law is that once you sign the document, it's then that you read everything and you understood everything before you sign. So you see the wallet that you put yourself into now. I cannot defend you again because you know some Lagos will take it that you understood everything before you accepted that admission. So, so what I'm saying is that we now that should also teach a lesson for all of you that when you are going to a transaction and you give a document, be careful that that document will also sometimes will make reference to another document or another law. So what I mean is that whether you read those laws or other documents that were incorporated by reference or not, if you read them or not, it's deemed that you read and understood them and they're binding on you. So it means that when we're talking about terms of contract, it's not just the document that you are holding in hand, but it also includes other terms that are incorporated by reference. So that is just what we're trying to look at here. So, but then in looking at this, you know, there are some terms that are, could be orally, those ones are known as oral, or parole evidence. When you see parole evidence, it means that it's oral evidence. So, the general rule is that parties are bound by the terms of the agreement. The four corners of the document is what bind the parties. So, you cannot, once a document is reduced into writing, the general rule is that parties cannot be allowed to admit oral evidence to vary what have agreed in writing. So if you accept your letter acceptance in writing, remember that they would have ever asked you to accept and pay acceptance fees online. In law, as I said, by evidence acts, those what you did online to the university by sending that acceptance to the university online is deemed to be, agreement in writing. And so when you see that what you have in that acceptance letter or what the university offered you and what you have in the acceptance letter, you cannot bring oral evidence to say, oh, university, this was, oh, we did not agree, we agree for this one, but it's not part of it. You cannot, law will not allow you to bring oral evidence to vary what you have agreed in writing. The only thing that law allow you that if you want to clarify some things, that they can admit oral evidence to make clarification, but you cannot change it by oral statements. So parties are bound by it. Also, there is not everything that is said. Remember that we spoke about um, invitation to treat. Do you see remember invitation to treat? Is anybody do you see remember invitation to treat? I'm asking the class. Do you still remember invitation to treat?
Yes,
What is it?
it's simply advertisement.
I don't understand.
Advertisement, like
No,
when a company should.
no. You are just giving. You are giving. You want to. That should be an example. You want to give an. It's like you without explaining anything, you want to give an example. Explain what it is. Then, if you want to give an example in advertisement, you give example. And even it's not every advertisement is related to trade anyway. There are some advertisements that are offers. That's what that was we learned. So, but first of all, what is invitated to trade? I'm asking the whole class. If you're not answering me too, I will not say anything again. No. I'll be waiting for you until when you answer it.
It's invitation to
Yes.
Okay,
treat is
Alex, go on. Alex, go on. Alex, go on.
okay, sir. So invitation to treat is the initial phase before an offer is made. It's the entire phase where negotiations are made before an offer is virtually made.
Okay. Ruth want to say something. Agbola.
okay. Invitation to treat is an invitation to make an offer. So it is not actually an offer itself.
Okay.
And it is not clear and definite. And that is why we have advertisement as an example. It is the preliminary stage to a definite offer. So it
Exactly.
is until when the customer makes consideration by making payment, that is when offer has been made. So the main
Okay.
objective of invitations to trade is to receive an offer. So that is why most advertisements are usually invitations to trade.
Okay. Thank you so much, Ruth. Thank you so much. So as you the two of Alex and Ruth, thank you so much for bailing out the class. I mean, I will just pay attention to you after the time all of us go. I know that some of you may even be in your offices, so you don't want to talk. You don't want your people to know that you are doing full-time program in University of Lagos. So you just join online and you mute. You don't want to talk. Oh, we will know. Now, so as I said, you see that not every statement, not every expression, not every promise made that will amount to a term of a contract. Some will just be a mere representations. It will not be, uh, terms of contract. So just the way, party would have exchanged some words promises at the beginning, but some of them will classify as invitation to trade, some will classify as offers themselves. The same thing applies when you want to classify terms of contract. Yeah, we want to clarify terms of contracts. So to determine whether a statement is a term of contract or mere representation, there are some tests that are applicable. Test number one, you could say on the slide yourself, the stage at which the statement was made. If the statement is made long before a contract is concluded, they are deemed to be the word is may. So the may or may not may be regarded as mere representation. Uh, but those that are made shortly before the conclusion of the contracts may be regarded as terms of the contract. So where the contract is, number two is where the contract is reduced into writing. Any statement not in writing will be deemed to be a mere representation. So if I've discussed, you are into a transaction, you want to go into a transaction, maybe supply of goods and services, consultancy, you know, delivery of importation, clearing goods and all of you have oral discussion, right? Now, but we wanted to now reduce that into writing. You did not say other ones. It's deemed that you know those things that are not reduced into writing were just mere representation. They were not intended to be binding by the parties. But where a party who made the statement has special keys or knowledge of the subject matter, then the one that's less knowledgeable, you know, those one person, whatever you say, you have someone that is knowledgeable and someone that is not knowledgeable. You have, for example, a patient and a doctor, you know, a lawyer and a client on the point of law. So a statement in that regard, a statement made by that a doctor, we consider to be a term of contract. That's someone that is not, skill or don't have skill or knowledge in that area of discussion and things like that. You could see cases there, I guarantee the cow and all of those ones say that they were intended to be a condition because the owner, the owner was the one that was making that statement. Compared with Godfrey, which is the second one. Yeah. So the second one said that the seller of the boat said, "Who can? Someone should read the last one that has Godfrey the same. Someone should read that so that we know we're following." Hello, is the class governor in this class?
Yes, I'm here.
Read this last sentence on the slide.
In EK versus Godfrey, the seller of a boat said it was sound, but advised the buyer to have it examined. It was held that this was a mere representation, not a condition.
So see that. So the point there is that when you are when you are into a contract and someone that this is the subject matter, but you have the right to seek for another advice or seek external advice and if you don't do that, then you cannot come back and be complaining that this and that, this and that. So just take note of when you are going to a contract, every statement or every expression made is very, very important and you must have to pay attention to it. So that's on hand, and now you see that the terms will be classified into there are different classifications of terms of contract. Some are conditions, some are warranties, some are fundamental terms. A condition is more vital than a warranty, you know. So, like, you know, like let's look at your between you and University of Lagos, for instance. What's the subject matter of the student, MBA student, and University of Lagos? What exactly are you people? What is the subject matter that you people have an agreement with University of Lagos? What is the subject matter? I want someone to explain that. What is it that you enter in agreement with University of Lagos for? Class, I asked a question. No one is answering me.
Good
Good
afternoon,
afternoon,
Prof.
sir.
Yes, yes. Someone has AEO 24909. Please change your rename, please, so that we know who is.
Okay, good afternoon, Prof. My name is Aaron. Yeah, the agreement we have with the School of Unilag is that to be awarded with a certificate of the MBE in any organization you want, you have to pass all the courses that was approved and signed by the Senate, and by doing the test, the assignment, and at the end, when the Senate mark the paper and everything, if you meet the target, the standard of the school, you will be awarded at the MBA certificate at the end of the course. That's the agreement between us, between the school and the
So the
MBA
the
certificate.
code, the cocoa. What is the cocoa?
The fundamental,
The
come
certificates,
again,
is it
Prof.
also? The cocoa is the certificate, is it also? The subject matter, the main subject matter is the certificate, is it also?
Yes, sir.
Yeah. So because so that if you were to go to Shomolu or go to Oshodi or go to Alaba Market and print out your MBA certificate, no one will come to University of Lagos now. You will not come. So, but what I'm saying is that look, that certificate with the subject matter, there are some things that you have to. There are some terms to it. You must attend lectures, do CA, do exam. So if you see that you may miss class one or twice, but still write exam and pass. Now, and still have that certificate. Now, but what happened? If you attended all the lectures, but you don't miss exam, will you still be awarded certificate? Will you still pass the exam? Is it
No,
possible?
no.
Exactly. So you see that if you look at the terms of that agreement that you have with University of Lagos, University of Lagos is not a human being that you can see. It's an artificial being acted, so we that are human beings are the one representing the staff, are the one representing the University of Lagos, acting on behalf of the University of Lagos. So even though the agreement you signed, I wasn't part of it, the University of Lagos have authorized me to teach you what I'm teaching you. And the management of the university from VC, deputy vice chancellor, directors, all of them are all of them are you know, what is called, they are what is called, you know, the hearts of the university, right? So you see, from that little example, the document is there with you, offer or admission, acceptance that you need, the terms of the contract, they're there. But the weight that are attached to those terms are not the same, which I just demonstrated now. You know, you can miss your attendance. You can miss lectures. You can write exam. So it means that miss lectures, missing lectures is a warranty. It's not as vital as exam itself. If you miss exam, forget about it. Even though you attended all lectures, it's not possible. But see that both attending lectures and writing exams are condition that has to be are terms of the agreement. So the weight attached to it is what determines whether it's a condition, a vital condition, or not. You know. So when you say that it's something that, and of course, you see the pulsars and spine and pound, betting and gay, all of them. You can Google these cases are online. You can just Google them. Google those cases. You can always need the answers there. I mean, what did happen in them? Then you have what they call fundamental term, which is of it has to is the one like in your own case now. Fundamental term is the is the certificate. Now, if the University of Lagos after everything, University of Lagos not can not give you the certificate, that will amount to non-performance. Because whatever we're doing here, if I teach you every day, I'm teaching you every day, I'm teaching you. By the end of the day, they don't give you that certificate. University of this team that University of Lagos has not performed their own, so it becomes a fundamental term. So you didn't just come here to attend the lectures, but the main thing, the fundamental thing is that certificate, which you are looking out for. So all of those things, whether you call it the condition, you call it the warranty, it's just based on the weight that you attach to that type of contract. That is just the point I want to clarify there. You know, what one thing also to know is what they call exclusion clauses. Terms. Some contracts with parties are allowed to limit their liability or to exclude terms. You know, when you are buying something that is not new, the general rule is that when you buy new thing, it should have merchantability quality. It should suit the function as a new item, right? So, but if the customer say, "Oh, this my own exclude, my liability exclude X, Y, Z," you have the right to, not to go into that contract. But once you go into a contract, I mean, with those exception, exclusion clauses, then it means that it's binding on you. Insurance contract, for example, the insurance company will promise to pay you if the risk occur. But there are so many exemption clauses that if you don't have a valid driving license, someone that the driving is not authorized, and all of those ones, they say they will not exclude you. So even in the case of insurance like this thing, you are supposed to do what you are supposed to um, you know look at the terms before you pay. So somebody that have insurance over your car, you will not even read those terms for once. You know, but that is meant for you to read and know those terms before you start paying for your insurance over your car, right? So you also have what is called implied terms, as I was saying before, that they are if you enter into agreement, you have the express term, and I would like to give you an example of your admission letter agreement between you and University of Lagos. That admission letter, there are some things that also imply into it. So even though you will not see them written there, but they're implied, and that's the point I was making. So there are three types of implied term: implied term by customs and trade, implied term by statutes, that's legislation, and implied by the court. So for every custom, the way of doing life, the culture of people is usually implied into any contract, even though you not see it expressly stated in the agreement. So if you go to Zamfara State, you go to some part of Kano State, or this core Muslim that state that have Sharia district law, you know, ladies cannot go, you can't wear jeans, you can't wear trousers and go in public places. You cannot have a public bus or public vehicle that has mixture of both men and women sitting together in one bus and things like that. So even though you enter in the agreement, you are working with the bank, while working with the bank, the agreement between you and the bank, but how the culture of that people is regulated in that place is implied, right? So even in Lagos State here, if there are some of these festivals, and then one of some of these festival that takes place in Lagos, say that the women should not come out. that by 6 o'clock nobody should stay outside. So even if you have agreement with someone and they say that Ikorodu from 7 o'clock nobody should come outside in Ikorodu, that means that you have to that kind of festival is implying your agreement. You cannot say no. You have agreement with Mr. A, so you want to go and perform your agreement. You are wasting your time. So custom of the people are implying to it. Professional discipline, trade. If some of you, if you would have belonged to so many professions, maybe chartered accountants, surveyors, professional. So all those your professional discipline, when you are going into agreement with anybody, those professional ethics are also implied into it. If you are going into agreement with someone and you are a lawyer, the rules of professional conduct of a lawyer apply into it. So if I'm just looking at the document like that, that is the agreement I'm entering into, forgetting that there's a rules of there are rules of professional conduct that is guiding me. If I don't go by those rules of professional conduct, I'm getting it wrong. And they may leave the agreement and find me wanting on that basis. So they started, as I said, all the laws of the country. When you enter into agreement, they might say that, oh, this agreement is governed by the laws of the Federal Republic of Nigeria. It's very common in all agreements. So what I mean is that whether we know those laws, and of course that's what the presumption, the in law, the rule is that everybody is presumed to know the law. So whether they enacted that law before you were born, whether they enacted because you are not busy, you are in class, maybe they already presenting with signing other laws, you might not be able to be aware of it. The last month, they signed four tax reform law. Whether you know it or not, those tax reform law, they will start implementing it, and you also be affected, whether you have seen that tax reform laws or not. You know, and so we have some of those other implied, section 12 to 30 to 15 of the Sale of Goods Act. Talks about things that are implied as to title. If you are selling someone selling a something matter to somebody is presumed that you have title to transfer or to sell. If I have a car stand and I come to you to buy a car from you, it means that you have a title in you. You have ownership and title to that car. So that if I pay you, I'll take the car. The same thing applies to property or lease or one of those. You must have title. It's implied. If you are selling things by description, you advertise something online, and I went online and I purchased it. That physical thing, something that I'm purchasing must correspond with the description that you have online. Suitability of purpose, merchantability of inequality. If you buy something that's new, it should have it as a new item and things like that. So this is implied by the courts. Um, this is implied by the courts. Um, Also here, all the court judgments, all the court's judgment, whether you are aware of it, to the extent that apply to the they're all binding by the parties, as the case may be, you know. So, from the state high court, federal high court, court of appeal, Supreme Court, of course, you know that all the decisions of Supreme Court binds all the courts in Nigeria. You know, they bind all the parties if the transaction that going into has anything to do with that judgment is binding, whether you are aware of it or not. You know, so just notice that for example, the admission letter you have, I'm not giving it because most common, or even your employment, those that are working, the employment contract that you have with your staff or your worker, know that that's employment contracts. Other things are applied into it. All the laws in Nigeria apply into it. The judgment that led may have anything to do with that which you are having apply into it. The ethics or the custom of that or trade, professional requirement of that, you know, that sector you're working into, they all apply into it. So it's not just that one page or two page that you're having that it will cost, that we thinking those are the terms of the agreement. No, there are other terms that are included into it or implied into it, either by custom or by trade or by legislations or by the courts, as the case may be. So do you have any question? That's all for the terms of contracts. Any question, please? Can you hear me?
I can hear you, sir.
I said, is there any question? Do you have any question? Okay. Can someone respond to my question? Do you have any question? If you
No
don't,
question for now.
just say
No, no question, sir.
No.
I think that is better. That is better than just be keeping quiet and me doesn't speak. Okay, so let's proceed to the next topic, which is privity of contracts with no capacity. Yeah, privity of contracts. Okay. Privity of contracts, right? So here, generally when you say someone is privy, it means that when you say somebody is privy to something, you are saying that person is part of something. Is part of something. So the doctrine of privity of contract, is that only parties to a contract can sue on it. In other words, a person who is not a party to a contract cannot bring an action or enjoy any benefit or be subjected to any burden under the contracts. So I still use the same example of your admission with University of Lagos. So what you have there is that you see your name. Your name is on the admission letter, not your sister's name, not your uncle's name, not your daddy's name, not your mommy's name, even though they may be the one that are paying you the school fees. So in the context of the agreement between you and University of Lagos, it's only you, University of Lagos, and your name. That's you as a person at University of Lagos. So if I pick that document, I will see the two of you as a parties to it. So even I'm here, taking lectures on behalf of the University of Lagos. My name is not in your admission letter. So I don't have a contract with you directly. It's University of Lagos I have a contract with you. So what I mean is that if anything happened to you that you want to sue now, you will sue University of Lagos. If University of Lagos want to sue, they will sue you. They will not go and sue your mommy, your daddy, or your uncle who is paying your school fees. So what I mean is that for every contract, there are always parties to it. So it's only those parties to that contract that can bring an action to enforce that contract, or they can be subject to any burden that coming from that contract. So that if you don't pay school fees, they will give you notice, must pay school fees. It's you that will give you that, but they can't go and write to your father, oh, come and pay our school fees. No, you write the child directly. No, the case may be. So what I mean is that if you allow it to go that way, it means that maybe contract for sale of somebody that have superstore or you have office that have branches. You find it difficult to have branches because it will require you to stay. You must be presently in any of those superstore to enter into an agreement with whoever that will come and want to have an agreement with you. You must be. They want to be physically present across anywhere because you are the owner of the property. You are the owner of the subject matter and things like that. So if we insist that only persons to a contract can benefit from it, that will limit some contractual or commercial dealing. So there are instances whereby parties will still benefit from agreements that they are not parties to. And so that's where the exceptions comes in. Agency, we would have done law of agency. An agent is someone that act on behalf of the principal with a third party. So an agent deals with a third party, but that agent has a principal. So by way of agreement, it is the agent that would be would be a party to a contract with a third party. But when that agreement is entered into with agent, it binds the principal. So even though the principal is not party to it, it's still binding. That's why even for property you want to lease for office or house, someone who comes in, I'm the agent. You conclude all the payment, everything with the agent. Sometimes might not even know the landlord, but then you pack in and you go and you start enjoying yourself. Things like that. So the principal can also sue the third party if the agent have given someone some sort of matter to the third party, credit, and the third party is not paying. The principal can sue the third party, and the third party cannot say no, you're not privy to the contract between me and the third party. I mean, and the agent. No, the principal can always sue, even though it's not a party to the contract between the agent and the third party. Insurance too, third party insurance contracts or comprehensive insurance contract, the one that you have on your cars, you know, the the is third party in the sense that if the car cause damage to another person's property, then the insurance company will pay that victim, the person that's that third party. So we will see that. But if you look at your insurance on your car now, there's no you can't see the name of any third party inside that agreement. So it's between you and that insurance company. Those are the only things that you can do that. But if your car now damages somebody else's property, that person will claim against the insurance company, even though that person is not a party to the contract, the insurance contract that you're having with you. The same thing applies to trust. You have the owner of the property who gives to someone else to trustee to manage on behalf of the beneficiary. Three parties are involved: the owner, the trustee, and the beneficiary. So the contract is between the owner and the trustee. But the beneficiary of that contract can sue the trustee to enforce whatever right or obligation that come out of it. Banks, commercial credits, all of them, covenants running with land. If you buy a land around airport, for instance, they say, okay, at that place you cannot build a high-story building. You cannot say that no, that agreement was with the government in those years back. You were not party to that agreement with the old landlord. So your own is you now develop it the way you want to develop it. No, there are some covenant that runs with the land all through. Even though ownership keep changing, may keep changing, but the covenant will remain the same. You have some two exceptions, right? Things like that. So this is all about privity of contracts, the general rule and the exceptions. There. You can read those cases: Price and Easton, Twiddle and Atkinson, and Dunlop Pneumatic Tire Company, Selfridge. Those are the cases that you should go and read. Gather the general rule and the exception. Yeah. Any question? Any question?
No question, Lisa.
Okay. Thank you.
There's a question in the chat box, sir.
Okay. Let me check. So why does the person not want to? Why does the person not want to ask? Don't want to hear our voice. You want to. Good morning, sir. Is there no way to shorten some terms and conditions such as those of a bank and some that are up to 5 years? Must it be as long as that? The quantity makes it difficult to sit down to read. So all of those ones are, it depends on the terms of the contract. You can whether it's one page, it's the same thing. Because the issue is that truth is like there's no agreement that will cover everything. No, can't cover everything. So it's the style that it becomes. It's the style. Even the one that is 5 pages, you can reduce everything into 1 page. That's all. So, like, you know, instead of if I enter into a agreement with the bank and the customer, you can just say the banking practices. In accordance with, you can say, oh, we enter this contract in accordance with banking practices. You are covered so many things that you don't need to start, you know, certain details as to which of the practice, because really banking practices are regulated. They are regulated. You know, there's time to go to bank. There's when you have to tender your check, and all of those things. So they are regulated. So instead of saying writing in 100 pages, you can just say banking practice in one sentence. You can still get it. So whether it's 5 page or 1 page, it's a question of style. What the parties will want. And the essence of doing the right thing just to human memory can fade. So you may discuss something today. If you don't document it, when the next 2 years now you start thinking, what did that say itself? And then it becomes a controversy. But if you reduce it into writing, you may keep that generation upon generation upon generation. Yeah, that's it. So have I answered that question? The person that asked the question, have I answered you?
Yes, sir.
Peace.
Yes, sir. Thank you. Yes, sir.
Okay, all right. Um, so we're going to the next topic, which is illegal and void contracts. Illegal and void contracts. So the point is that the point is that oh, we have indicated that for a contract to be valid or the contract to be enforceable, what is required. If I'm asked the class, if you want, what are those things that must be present for you to enforce a contract? What and what and what? I'm asking a question. If someone is hearing me, or I beg, that person should answer me. I beg.
Consideration.
Huh? Yes, 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 yes. I'm here. I'm waiting. I'm waiting, please.
Oh, sorry,
What are
sir. I
those
didn't
things?
get the question.
I said, what are those things that will make a contract valid and enforceable?
Hello, good day, Prof.
Yes, cancel.
Hello, Prof.
I can hear you. I can hear you.
Now, the requirement that can make it to be a contract to mean number one, consideration, acceptance, offer, and legality.
Let's hear from another person. You tried.
Okay. The first element should be offer.
Okay.
So we should be accepted. Once it is accepted, then consideration will be put in place. So
Okay.
then we also have the legality and the writing. So the contract should be in the written form because that is the best way to communicate it.
Okay. Let's hear from another person. Thank you. Any other person?
So I would say misinterpretation of the terms. Maybe what I read is not what it actually means, and I do contrary to it. I think that will make it to be void. I don't know.
Uh-uh. What is it? What is that must be in agreement to be for that agreement to be valid and enforceable? If you say that this agreement is valid and enforceable, what and what must be present? That is the question I'm asking. Please, what are those things that must be present? I'm expecting the answer. Oh. Let's go. There are about 40 persons, about that some people. Nobody. Oluwole, Anu. What are the elements of valid contracts? Oluebubechi Innocent. What are the elements of valid contracts?
Hello, sir. Good afternoon, sir.
What are the elements of valid contracts?
Offer, acceptance, consideration, intentions to create legal relations, and valid capacity.
So that's all that I'm looking for. That's the thing that I'm looking for. So people, I'm surprised that people not giving me different answers, and I'm shocked. So for a contract to valid, that's all that you need. The elements of the contracts must be there. So assuming that I ask this question in the exam now, I mean people will fail. Yeah. So, but the point that we are looking at here is that even though a contract will have all the elements, offer, acceptance, consideration, intention, create the relationship, and value capacity, even though a contract may have all those, that contract may still, you know, may still not be enforceable. So it's a different thing having the elements of contract present, and it's a different thing entirely for the contract to be enforced. Right. So there what they call vitiating factors or factors that can destroy a valid contract. And there are some could be mistake. It's what they call mistake, misrepresentation. You have illegal and void contracts, duress, undue influence, and all of those ones. Now, but the one we're focusing here is illegal contracts. You know, and we're saying that a contract is illegal. You know, what I say very simple that a contract has all elements, but it cannot be enforced because it is against the law. Remember that we talk about terms of contract. We say that imply as to statutes, imply as to courts. So it means that all the laws of the country are applied in that are implied in the agreement. So if you enter into a contract and the subject matter violates the law or public policy, then it is illegal. It could be at the time of forming the contract, it could be at the time of forming the contract. You know. And I give you an example here, to commit a crime, for enter into a contract to commit a crime, or to sell prohibited drugs, or prostitution, or hiring of underage workers. You know, all of those ones, they deem to be illegal contract because they violate the provisions of the law. So, a contract for committing crime and all of those ones. There are very interesting cases here, examples of you know illegality. So you will see that I will still use the example of University of Lagos. You know, the contracts at the time of admission is legal. You have all the element of, but in performing the contract now, you decide to cheat exam. You cheat in the exam. You carry books, everything, and you enter to write the exam so that you can pass. It means that in performing the terms of the contract, you did it, you perform it against the law. It means that the university can send you away. University can send you away. So you see that even though there was offer acceptance, consideration, you are paying school fees, the intention was to create legal relationship, all of you have capacity. But in performing the contract, you perform it against the public policy and laws of the country, you know. That should uh, not be enforceable. There's one case here is the case of very interesting case. Everett and Williams, an armed robber. Two armed robbers have an agreement to go and rob a bank and share the proceeds of the crime. They enter that they go. They had agreement to rob a bank and share the proceeds. You know, they agree on a percentage. So they had their prayers, went for the robbery, was successful, and when they now come to sharing formula, the other one was short-changed. They didn't give him what was agreed. So he went and met a lawyer. That lawyer now went and sued the other armed robber, sorry, to claim the suit to the court and to claim his own share of the proceeds of the crime that was robbery that was done. You know, and the matter was in court. So if you are a judge and this matter is brought before you, what would you do? What would be your own decision? Yes, I'm asking the class. Someone should respond to me quickly. There's no time.
Hello, sir.
Yes. Lekon.
Since it is an hello, sir. Since they engage in illegal business, so I will, as a judge, even get the two of them arrested and be prosecuted as due.
Someone has come to you for remedy to help me. So you now arrest the person again. Interesting. People will run away from your court. Oh. Yes, any other view aside from Lekon? Any other view? Lekon, thank you anyway. Any other view? Any other person that wants to come? What will you do? I'm just asking. What will you do? Or do you any? That may not do any. Okay. Who want to say something?
Okay, sir. So I'll rule in favor of the other guy that wasn't giving an equal share, but afterwards, then it can now be forwarded for legal actions based on the acts that they have done. That's thefts.
So, an armed robber has gone to commit a robbery, and it's coming to you that I committed robbery and I was not given my own share of robbery. So, as a judge, you order that the person should give his own share from the robbery.
Yes, because it was a contract. They already agreed to equal share, so it will be shared equally amongst them. Then the law will take its course for the punishment of the acts.
Okay. Let me hear from other person. Tina Okwara. Tina Okwara, let's hear from you. Who is Tina Okwara in this class? Yeah, I can see your name here. I'm calling you. Respond to our question. Remember that the class is recorded, so if you're not responding, it means that you are not in this class. Who is Tina? Tina. Okay, let's go to Ademola. Ademola, let's hear from you. Ademola Sola, let's hear from you. Osine Kende, Samuel Dada, let's hear from you. Gloria Bath, let's hear from you.
So
Class
I,
governor.
so I think I will follow with the ruling from Damilola that she said the rule in favor of the guy that brought the issue to the court, and then later on will not treat it as per theft.
Okay. Catherine Uwa. Catherine Uwa. Emmanuel Bassi. Uh, Class governor. Is the class governor in this class? No, the best. Is the class governor in this class? Hello.
I think she just lost her with network, but she was there before.
Oh, wow. Okay. So you see that many people are not in the class because I'm calling and people are not responding. They just join and they're not there. So
Yes, sir,
help
I'm
me.
here.
Okay. So you see that Ozoma Abi, read this case. Read if we're watching read the case of Everest and Williams. Ugoji, can you read that case? Everest and Williams, can you read the case?
On the screen, on your screen, or do you want me to read out the case itself?
On the screen now, it's on the screen.
Okay. Everett versus Williams. An armed robber sued his partner to claim his own shares of their loot, valued at £200. The court declared the right as scandalous and impertinent. The solicitor was fined for contempt while the parties were executed.
So why is it so? Because the law is that if you go to the first paragraph, that's robbery is it prohibited or is permitted in Nigeria? I mean globally, robbery is it permitted or prohibited by law?
Prohibited by law.
Exactly. Good.
Prohibited
So
now.
if you not enter into a contract against what has been prohibited by the society, that is the point we're making. That contract is illegal, and the consequence of that, if you read the first paragraph, that the contract is what is void. Is void. When you say that something is void, it means that it doesn't exist in the eyes of law. So you can only enforce a contract that exists. But if in law, they're saying that what you have done is against what the society prohibits, you cannot run to the same society that prohibit an action to get protection from the same way. And if you look at the grounds for illegal contract there, unwillingness to aid such contract, because it means that you are aiding people to go into crime. And people imagine that someone has gone to commit robbery and is getting justice in court. People will not trust the court again. You ever encourage people to do more of such things. Because if I go to bank then and I rob the bank successfully, I can go to court and the court will give me judgment. I mean, so you see that's why such court judgment are not enforceable, right? So you have void contract, for instance, contracts that the law disregards. In the eyes of law, the deem that they did not exist. You know, many of them are there. You know, is another contract for sale of land. When you want to buy land or transfer interest in land, the law requires that such agreement must be evidence in writing. Must be evidence in writing. So Savannah Bank and Ajiro, there was a mortgage transaction. Somebody that working in a bank, if the bank wants to borrow money, they will say, bring property, sign a mortgage that if you cannot pay the loan, they will sell the property or manage the property and cover the loan. That mortgage must be registered with land registry, and governor's consent must be obtained. You know, so if the bank cannot obtain governor's consent, they cannot enforce such mortgage, and this is what is also happening here. Contract in restraint of trade. Someone that are working, your employer have restrained you from, that even after leaving employment, you cannot deal with some customers, or you cannot practice the same line of business close to where they already established their own, and things like that. And you signed, So in the past, such agreement that were in restraint of trade in the past, they were considered void. That means that you cannot enforce such agreement. So that if you restrain an employee from carrying on similar business after leaving the employment, it was void. It was not enforceable because they used to look at it as encouraging monopoly. But the law has changed now, to allow that. So if it's justified, if it's reasonable, if you can prove that, you know, by stopping that person from working around your own business premises or carrying on such business 2 years after employment, 1 year after employment, that doesn't is not unreasonable, or it protects the interest of the employee or the employer, then the courts can always allow that agreement to be enforced. So, so those are just the things that I need to highlight for you with respect to illegality. You can read the rest for in any they're online. Most of all these things are online. So as I said, there are other factors that can destroy a valid contract: mistake, uh, misrepresentation, duress when you are forced to enter into a contract, or undue influence. Then, as I say, illegal and void contract are also part of it. So what I mean is that a contract that has all the elements of valid contract may still not be enforceable if that contract is against the laws of the country or public policy, as the case may be. Yes. So any question on that? So if anybody that has question can just raise up his hand. Just raise up your hand. I will draw my attention to that. I will do that, sir. Okay. So anything that has a beginning must have an end. We're gradually coming to the end of the class. This is the last topic: discharge of a contract, or termination of contracts. Everything that has a beginning must have an end. So just as an offer, we say that the offer can be terminated by rejection, by revocation, by lapse of time, and all of by death of the parties, and all of those ones. You also have discharge or termination of a contract. Can someone read the first paragraph? Can someone read the first paragraph?
Okay. A contract is discharged when the contract is brought to an end and the parties are free from their mutual obligation. A contract may be discharged in four ways: by performance, by agreement, by frustration, and by breach.
Exactly. So you see that these are the four ways, and of course you would have seen this severally in your past questions because they are the common areas that is set exam question. You would have seen this severally on the past questions. So discharged by you know we will discharge by four ways: by performance, by agreement, by frustration, and by breach. Now by performance, once parties carry out their respective obligations, that's all. University of Lagos, attend your lectures, do your exam, pass them, university will give you certificate. So once you've done that, university will give you certificate. that contract has come to an end. Or buying property, or buying a warehouse, or leasing a warehouse, or clearance, importing goods, and all of those. So once you perform your own part, and the other part also perform its own part, it is done. You know, you know that brings it to an end. But then there are some part of it issues has to do with substantial performance or several contract or prevention from performance exception that has to do with. Because the rule is that performance must be exactly, must be fully. But then there are sometimes that the person may not, maybe construction of a building. You want someone to a building, for instance. The person have done everything, but maybe one net is missing, or one padlock or one door is not as agreed in the terms of the contract. You know that so the such contracts would be valid because it will pass the test of substantial performance. And there are also some contracts that are divided into parts. Several contracts, one contract but divided into several parts. Like building, you have milestone. You lay foundation, they'll pay you. You might do the first decking, they'll pay and things like that. And then there are sometimes that one party will prevent you from performing your contract, your own term, sorry. You know, so all of this determine what the other party gets, if it's discharged. By agreement, the way the parties will also agree to enter into a contract, they can also agree to, discharge their relationship. It's as good as that. Discharge by breach is when you fail to carry out the terms of that contract. You have breached the contract because you failed to carry out the terms of that contract. But there's an aspect that I wanted to take note of: anticipatory breach. Breach of contract can be actual or can be anticipatory. The actual one is when you fail to do what you're supposed to do at the time that you were supposed to do. Now, but then there are sometimes that the time that you are supposed to perform that contract has not arrived, but a party has shown an indication or something has happened to show that that party is not willing to. If that day comes, the party will not perform that contract. That is usually known as anticipatory breach, and you can sue. So imagine, for instance, the class governor is doing a party. He has entered into a contract with the MC. The party is this evening, and he heard that, or he discovered that the MC is traveling, or is traveling this afternoon to one other country. You see that even though the time to perform that contract is in the evening, the fact that you heard that this person is traveling this afternoon shows that that person will not be available in the evening. So that is anticipatory breach, and you can sue for that basis alone. You don't need to wait till that time. So you can also read that on the screen, the second paragraph on the screen.
Okay, so second paragraph. Anticipatory breach occurs when there is a contract between two parties to be performed at a future date, and one party has shown either by words or action that he has no intention of performing his own side when the time arrives. A party could
Exactly.
sue for, should I
Yes, go
go on?
on.
A party could sue for breach of contract, notwithstanding that the time agreed upon for performance has not yet arrived.
Exactly. So anything that will take, show that this person will not be there. Once you can sue for a breach of contract, even though the terms are not arise. So the fourth one is discharge by frustration. You know, frustration is not used in the context of general palace. That we say, "Oh, I'm frustrated. I don't know what to do again. This frustration of it." No, that's not what they're talking about. Here is that parties have entered into a contract, but before they will perform that contract, an event occurred without their fault. But it becomes impossible to perform that contract. So first parties have entered into a contract. Before they will perform the contract, an event have occurred. It's not their fault. But because of that event that occurred, it becomes impossible for them to carry out that contract. It's not their fault. They can't go on with that contract. It's not about the issue of it's too burdensome. No. If you enter into a contract and it's difficult for you to perform, that one's a different thing entirely. That was not frustration. This one, the event has come, and you cannot perform the contract as agreed. You know, so it's not the fault of the party. So if it's the fault of parties, it's not a frustration. But that terminates So there are many events that can do that. Many events, maybe like between University of Lagos and the students. If there's ASU strike, you know, you cannot go on with the lectures. And so you cannot say that the contracts, but even strike is different because you can even come out, you may even resume after that. You enact a law. There are some drugs that maybe someone have employed you to sell a particular drug, and government have passed a law prohibiting the sale of that drug. What do? You cannot go on that employment because of enactment or war. This war, or maybe government policy. Someone has sold a house to you. You want to buy a property in Lagos. You have entered into agreement before you pay for the property. Government have demolished that property because it was on the channel, water channel. It's not the fault of either party, but that cannot contract cannot go on. So there are many of such situations that will make it contract frustrated, illegal, performance, destruction of the subject matter, and things like that. So, but the consequence of it is that it brings the contract to an end automatically. So, but what you know is that once the contract is brought to an end, if I incur some cost before the contract was brought to an end by frustration, then you will be compensated based on what you have done. You know, so the part that you did before the frustrating event coming will be you'll be compensated. But the one that you cannot do because of frustration, you will not be allowed to seek for any compensation for that. You can read these cases on the screen, Fibrosa, Stoker, and all of those other cases. Just read them. They're all online cases. Shadler is Webster, they're online, you know. But the most important thing which I wanted to take home on frustration is that look, parties have entered into a contract. They are willing to perform that in the future date, but before that time, an event happen, and because of that event, they cannot perform the contract. And most will say that they were not responsible for that event. If they are, that will amount to breach of contract, of course. If someone is one, somebody caused that, so some of them will be act of God, maybe earthquake, fire, thunder, lightning, those things that are from flooding, act of God or act of government enacting a law, NAFDAC making prohibition and all of those government policies and all of those ones. You know, so those are the ways by which you can discharge a contract. So when a contract is discharged, next is remedies. Um, what are you going to do? Is remedies is the next one. Um, remedies are kind of compensation that a party will get, you know, in view of a breach of contracts. When there's breach, whether actual breach or anticipatory breach. When a contract comes to an end and there's need to another party is to be compensated. That's where the issue of remedies come in. There are, there are two main categories of remedy. You have the common law remedy and you have the equitable remedy. The common law remedy is one which is damages, and then the other equitable remedies are examples are restitution, injunction, specific performance, declaration, and all of those ones. We were focusing only on damages. This is the most important one, which is the most popular one. You know, is what, as I said, damages is what the party is, that compensation that is paid to a party. And usually it can be evaluated or quantified or or it may be stated in the agreement. It said that look, if this contract, this person breaches contract, these are the damages that will pay. Contract of employment. If you want to terminate, you give 1 month notice. If you do not give 1 month notice, you pay the other person 1 month's make 1 month payment in lieu of notice and things like that. So you take note of all of those things. Okay. Okay. So the one of the principles of damages as demonstrated in the case of Hadley and Bazender, you know, it's a case that you must read. Read that case, very important in determining the the issue is that remedies damages must be not be remote. It must be closely connected to the loss of or to the claim made. So you read the case of Hadley versus Bazender, someone who shaft was a floor company a shaft to he gave a driver to take a shaft to engineer to repair for them. The driver delayed, and of course, because of that, they said that they didn't take to the engineer on time, and because of that, it wasn't returned on time, and so they lost. They would have those things that if there was no delay, they would have, you know, done produce so many of their products to sell, but because of delay by the driver, they could not do that. So the question was whether the loss of revenue they are talking about and the delay of the driver, whether they are closely related. That was, or are there other factors that would have caused the loss, or it's just the delay of the driver that would have caused those huge loss that they were claiming? So in that, the court said that loss of profit could not be fairly be considered to be consequence of that delay that they alleged for the driver. So, but what we're saying is that look, there are many other examples. Someone compensating someone for or this case of somebody in the has a gun in the car. He enter a car, the car did not have a brake. They were driving, they hit a gallop. Because of bad road, the gun went off in the car and killed someone. The question is what was responsible for that killing? Is it the gun, or is it the bad road, or is it the car that did not have brake? Hmm? Class, why would I kill that person? The gun in the car, driving the car that you have a person that are carrying a gun in the car. The car was don't have brake. The road is bad, and they hit the gallop, and the car, is because of that. So what would have happened? Is it the car, or what exactly happened? Is it the car, or yes? Is it the gun or the bad road or the car? What would have killed the person?
I suppose we say the cancer.
So what happened if there's no gun inside? So you see that.
Okay, there we it's logical.
Uh, so you see that's how it was. Sometimes so many things would have happened. You got wounded, they took you to hospital. The what they used to treat you was not treated. Then from there you contacted something else because you didn't have some ailment. So you see, so many things can link up, but the issue. So you have to select which one is the major cause of this loss. So if that which is the major cause of loss is not related to the agreement, then you cannot pay damages. That's the point making that it has must cannot be should not be remote. It must be closely linked to the cause of the loss. So measurement of damages. Damages are not meant to punish; they are meant to compensate. So the loss of again, they use usually sometimes if they are not awarded, they want to go to always look at it. Um, you know, main rules whether is it remote, and then what are the steps that you took in mitigating the loss? So, like that's Hadley and Bezender, for instance, the coach said that look, if it was delayed and you know that you lost so much money. Why don't you to mitigate the loss? You should have buy or bought a new one, to mitigate the loss. So the court will still ask the question. Yes, when that breach occur, you so someone is to secure your house. The person was off was illegal. He was not on duty that day. That's breach of contract. Now, but you allow your door to be open so that if they come and steal your property, you sue that person for damages. No, the court will not help you. You would have taken step on your own to mitigate the loss. That's why, even as cars, you have insurance company, you have insurance cover, over your car. It may be fire policy. Yet you still have fire extinguisher in the car. Yes. So your car cannot catch fire, and then you fold your hands and are looking at it. Let it burn down. Man. Shey you have insurance. Insurance company will pay me. No, no, come on. The law cannot allow you to do that. You must have fire extinguisher and all those ones in the car. You must take steps to mitigate the loss. That is where the courts will help you. There are cases there which expect you to go and read. And lastly, is damages for no. All those one we're talking about is monetary compensation. Monetary losses that has monetary value. But then you have no pecuniary losses, injury to feeling, mental distress, annoyance, loss of reputation. Someone has lied against you in your office. The breach of contract, the way they terminated your contract, you have some mental distress. You have bad people are looking at you as you don't have any reputation, your anger, and all of those ones. In the past, before now, such were not actionable in law of contracts. You can only sue for mental distress, bad feelings, annoyance to your feelings, your annoyance to your reputation, and all of those ones. They are only actionable in, in, you know, in law of torts only. But today, they exist under the law of contract as well. So if there's a breach of contract and that affected your mental distress, that affected your reputation, or caused you annoyance, something that happened, all this mental distress, you can sue now under breach of under as a remedy under the contract. At the case will be. Like so, ladies and gentlemen, that brings an end our discussion on law of contracts. So time for questions. Do you have questions?
No questions, sir.
Okay, if you don't have questions,
Sir, hello, sir. Good afternoon,
So
sir. Sorry,
I
sir.
have a request.
yes,
Okay.
yes, please, yes, I'm with you.
Is it possible that after signing the contract, maybe you then went back to go through it, you settled out to not read through? Can you still come back to say no? I don't want this anymore? Because there are sometimes due to is it like called enticement, people kind of entice you, oh, do it now, it's possible, just sign it right now. Then out of duress you just signed it. They later went back to go through it properly. And then find out that there's some things that you don't want that in the you don't want that you don't agree to that in the contract. Is it possible for you to go back to say no, I don't want this contract anymore? I don't know if you understand my
Yes,
question.
yeah, of course, I do. Parties have the right to ever negotiate. But what we is that to be safe, you would have added that as a clause in the agreement itself. Because if you want to negotiate, but the other party say no, I don't want to. That disagreement. There's sometimes that you enter into like a contract. This what they call you may sign it, but you may have a defense that look, oh, this is not my contract, this is not my deed. That what I had in mind is not this. So because a contract in writing, for example, represent what you have in mind. So if they capture it wrongly, after signing it, you now discover that, oh, this is not what we intended. You can immediately protest that no, because this is not what we intended at the beginning. No, and even if the contract is ongoing, but you want to, you can what they call novation. You can see go and negotiate the terms of that. So those clauses that you feel that They don't actually represent. It's allowed. That's why the parties usually they allow parties to change the terms of the contract subject to the consent of the other parties. That can be done. It's a free will. It's not cast in stones. It's a free will. You can all freely negotiate in and out of the contract as the need arises.
All right,
So
sir.
that's it.
Thank you.
Yeah. Yes. Yes. Slide will be yes. We'll find a way of giving you something. Yeah. Like you read something. Okay, so if there's no question, then we'll end this contract here. My colleague will come in for other part of the business laws. If there's no question, I'm available. My line is there. If you have any question through your class governor, she has my line. You can always reach out to me for anything, any assistance that you may need while your program lasts. Right?
All right, sir. Thank you so much, sir.
Yeah,
Thank
you're
you,
welcome.
sir.
You're welcome.
Thank you, sir.
You're welcome,
Yeah.
Kansas. Yeah. All
Yes.
right. Bye bye.
Bye.